Court filings are public records, and they carry legal force beyond politics. When allegations enter a judicial docket, institutions are engaged, and constitutional speech protections are tested. Defamation law sits at the fault line between reputation and the First Amendment, and misuse of that system can chill scrutiny of power. This dispute now moves from media narrative into procedural combat, where evidence rules apply and consequences extend beyond image management. A defamation war has been triggered, and the legal counterstrike has already begun. Defamation war triggered after legal threats turned into open court action and reputational stakes escalated fast. A demand for retraction became a procedural fight, moving from private warning to judicial arena. Lawyers stepped in, language hardened, and the dispute shifted from narrative control to evidentiary burden. This is how civil litigation begins when public figures claim reputational harm and journalists refuse to withdraw reporting tied to alleged past associations. The conflict is no longer rhetorical, it is structural, governed by rules of pleading, standards of proof, and constitutional speech protections. A declaratory judgment counterstrike followed, calculated and deliberate. Instead of waiting to be sued, the writer went to court first, asking a judge to affirm that his statements fall within protected reporting. That maneuver changes leverage. It reframes the issue from defense to legal clarification. Anti-SLAPP principles hover over the case, designed to deter lawsuits that chill speech on matters of public concern. The court must now examine whether the reporting was reckless or grounded in sources, interviews, and documented material. Motive does not decide the matter, process does. At the center are allegations of historical social proximity involving powerful individuals and disputed accounts of introductions and environments decades earlier. The plaintiff side calls the claims false, damaging, and irresponsible. The defense side signals it possesses interviews, notes, and recorded material it believes supports its version. None of that is evidence yet, not until authentication, admissibility rulings, and sworn testimony occur. That is the line between accusation and proof. The legal risk cuts both ways. Filing or provoking defamation, litigation opens discovery channels. Emails can be requested, calendars examined, communications questioned under oath. Plaintiffs seek vindication, but procedure can expose more than intended. Truth, or substantial truth, defeats defamation claims. Reckless disregard revives them. The courtroom becomes the filter, not headlines, not films, not political messaging. Anti-SLAPP legal shield moves to the foreground as the case shifts from accusation to procedural defense of speech rights. These statutes exist to prevent powerful figures from using litigation costs as pressure tools, and courts treat them as early gatekeepers. A defendant can argue the lawsuit targets protected expression tied to public interest reporting. If the judge agrees, the burden flips quickly, and the plaintiff must show a probability of success on the merits. That means evidence, not outrage, not optics, not political standing. This protection does not declare statements true. It tests whether the reporting had a reasonable factual basis and whether it was published without actual malice. For public figures, that standard is high. Knowledge of falsity must be shown, or reckless disregard for truth. Journalistic process becomes central. Notes matter, sources matter. Recorded interviews, if they exist, become pivotal. Courts look at method, not volume of attention. The shield is procedural, but its impact is strategic. Discovery opens the vault once litigation advances past early dismissal efforts. That stage alters risk calculations for everyone involved. Lawyers can demand communications, travel records, financial links, and third-party correspondence. Subpoenas can reach assistants, agents, and institutions. Depositions place witnesses under oath, with penalties for false testimony. Memory gaps become issues. Inconsistencies become leverage. Silence becomes difficult. For plaintiffs, discovery is double-edged. Seeking to prove defamation may require exposing personal history to adversarial scrutiny. For defendants, claiming truth or reasonable belief invites review of sourcing foundations. Courts supervise scope, but relevance standards are broad. If allegations involve historical associations, social events, or immigration processes, document trails may be requested. Even absence of records can be argued over. This is where legal theory meets personal exposure. A lawsuit meant to suppress a narrative can compel structured disclosure instead. Judges balance privacy against evidentiary need, yet once discovery begins, control narrows. Protective orders can limit publication, but not examination. The courtroom becomes an extraction mechanism for facts or for proof of absence. Either outcome shapes liability, and public consequence follows the legal path. Epstein Association allegations sit at the core of the dispute, and they carry legal sensitivity because they connect social presence with later criminal findings involving other actors. The filings reference past gatherings, elite introductions, and overlapping circles in the late 1990s and early 2000s. The defense position stresses a key rule: proximity is not proof of participation. Courts require knowledge, intent, and conduct, not inference built only on photographs or guest lists. Still, when such associations are raised in sworn filings, they become part of the evidentiary battlefield. Lawyers examine who was present, who arranged meetings, and what each person knew at the time. That process is slow, document-driven, and adversarial. Statements attributed to deceased individuals add complexity, hearsay rules apply, authentication standards apply. A party cannot simply repeat a claim without establishing origin, reliability, and context. If recordings are alleged, chain of custody becomes central. Defense counsel will question editing, timing, and motive. Plaintiffs will argue fabrication or distortion. Judges act as gatekeepers before juries ever hear disputed material. That filter determines whether allegations remain rhetorical or enter formal proof channels. Visa scrutiny questioned becomes a separate but related thread. The EB1 category is reserved for individuals showing extraordinary ability, evaluated through regulatory criteria. Petitions involve documentation, expert letters, and agency review. Allegations suggesting outside influence or facilitation must confront administrative records and adjudication files. Immigration law relies on paper trails. Claims of improper assistance require evidence of false statements or unlawful inducement. Without that, speculation has no legal force. Linking immigration outcomes to social relationships is legally delicate. Correlation does not equal causation. Courts look for direct actions, financial exchanges, or documented intervention. Absent that, argument remains conjectural. Still, once raised in litigation, the issue can open requests for immigration files, sponsor communications, and agency correspondence. That is how a reputational lawsuit can evolve into regulatory examination, expanding the scope beyond the original dispute. Flight log defense strategy emerges as a central rebuttal line, built on documentary absence rather than narrative denial. Counsel points to aviation manifests long discussed in prior proceedings, noting that certain names do not appear in recorded passenger lists. The legal aim is narrow: to show no documented travel link to flights later tied to criminal conduct by others. Records matter in court, paper trails carry weight. But lawyers on the other side stress a counterpoint. Absence from a specific log is not categorical proof of non-association. Aircraft records can be incomplete. Nicknames appear. Staff entries differ from guest entries. The evidentiary fight becomes technical, focused on authenticity, completeness, and interpretation of archival data. Courts treat such documents as pieces of a mosaic, not final answers. A manifest may show presence. It may show nothing. Neither alone proves knowledge or intent. Judges instruct juries on limits of inference. Defense teams argue documented non-appearance undermines reckless reporting claims. Plaintiffs argue reporters cannot imply involvement without hard proof. The debate is about what a responsible journalist may state when documentation is partial. That is a defamation law question, not a moral one. Deposition risk exposure follows closely behind. Once litigation survives early dismissal, sworn questioning begins. Depositions are structured, recorded, and conducted under penalty of perjury. Lawyers ask about meetings, conversations, introductions, and memory of events decades past. Specific dates surface. Locations are revisited. Prior public statements are compared with testimony. Inconsistency can damage credibility. Precision becomes essential. For high-profile individuals, depositions carry reputational hazard beyond legal risk. Transcripts may become public through filings. Answers given under oath differ from media statements. Counsel prepares witnesses carefully, yet unpredictability remains. Opposing attorneys probe for gaps, contradictions, and undocumented assistance from third parties. Even denials become evidence if later contradicted. This stage pressures settlement discussions. Exposure expands. Control narrows. What began as an effort to silence allegations becomes a structured inquiry with compulsory disclosure tools. That is the leverage discovery creates, and why defamation litigation can evolve into a fact-finding mechanism neither side fully contains. Actual malice legal test stands as the decisive barrier in any defamation action involving public figures, and it shapes every move in this dispute. The plaintiff must prove the defendant knew statements were false or acted with reckless disregard for truth. Negligence is not enough. Poor judgment is not enough. The standard is constitutional, built to protect open debate about powerful individuals. Courts look at what the reporter believed at the time of publication, what sources were consulted, and whether contradictory evidence was ignored. Internal notes, recorded interviews, and communication trails become critical. Motive to embarrass does not equal actual malice. Knowledge of falsity does. Judges often resolve this issue before trial if evidence is insufficient. Summary judgment can end the case. That makes early procedural phases decisive. Anti-SLAPP motions, evidentiary hearings, and sworn declarations converge around this standard. The law asks a narrow question: was the reporting fabricated or recklessly indifferent to truth? Emotional reaction outside court has no role. Legal thresholds govern outcomes. Courtroom over narrative control defines the broader institutional clash. Public relations campaigns operate through image, timing, and message repetition. Litigation operates through filings, testimony, and evidentiary rulings. A film release, interviews, or public statements cannot alter burdens of proof. Judges do not weigh cinematic portrayal. They weigh admissible material. Once a case enters discovery, narrative management loses dominance. Procedure dictates pace. Subpoenas override preference. This shift explains why legal advisors treat defamation threats cautiously. Attempting to suppress a story can trigger judicial examination of the very facts at issue. Protective orders may limit disclosure outside court, yet within proceedings, scrutiny deepens. The arena changes from persuasion to verification. Statements are parsed line by line. Sources are identified or challenged. Context is reconstructed. In that environment, reputation defense becomes evidence defense. Victory depends not on volume of denial, but on documentary clarity and credibility under oath. The courtroom becomes the final filter, and legal standards, not narrative strategy, decide which version survives judicial review. This conflict exposes strain inside core systems, where reputation defense, press freedom, and judicial process collide. Public figures use courts to fight narratives, yet courts demand proof, not image repair. Media ecosystems fragment, trust erodes, and legal tools become political instruments. When defamation law is pushed into strategic warfare, discovery becomes a weapon, and transparency becomes accidental rather than voluntary. If this path continues, more disputes will bypass public debate and move straight into courtrooms, where unelected judges, not voters, shape what the public is allowed to know.